Good morning. In legal education, our entire process outside of class meetings, our cycle, our sequence that takes us from class to class is in need of dramatic improvement. To borrow an expression from the tech industry, we need disruptive innovation to our process to make it better. And I'm here to talk today, given what we know about the brain, given what we know about learning theory, we need to question every aspect of what we do and the very framework from which we operate. First, today I'm going to talk about how our current cycle, how our current class-to-class process is actually harmful to our students. Then I'm going to talk to you about two very simple, disruptive innovations to our process to make it go forward. Now, first, why is it harmful to our students? We learn a lot today from molecular biology and neuroscience about what's going on with the brain functions and what is important to our students for their learning. And one of the things that has been isolated in all the material that is made available to us now is stress. Managing stress is as important as exercise and sleep to the brain function. And essentially, stress presents in two very distinct ways for our student. One, positive. It can actually enhance performance when in short bursts. It can, I don't know, let's say, power you through a speech without notes in front of a large crowd. That's that adrenaline rush. But the other type of stress, prolonged stress, sustained stress, stress that one perceives as outside of their control, is very bad and leads to lots of different health risks for our students. Our bodies simply were not meant to secrete those chemicals and be in a flight or fight mentality for that long. So, I actually contacted a best-selling author of a book called The Brain Rules and a molecular biologist named John Medina. He wrote this book. It's a wonderful book, and he isolates stress within it. And I asked the question about our role as the professor, and it's no more good news here. And that is, much like the way a witness sees a crime, and instead of focusing on the identifying feature of the criminal, instead focuses on the source of the stress, the weapon focus instead, our students can actually be blocked in their learning of the material and focus instead on who is responsible for their stress, us, the professor. So let's look at our cycle quickly. Let's look at first what happens before class. We break up the reading, the assigned readings. We send our students on an unguided tour of the wide and varied voices of the appellate courts, right? We say, go find the answers before they know what they're looking for. We say, use a language that you think you know, but you really don't. Try to distill, try to glean from these cases the skills of problem solving and analysis that you're going to need to solve a problem like this in the future. See, we as professors, we think that the process to go from before class to class is like a challenging crossword puzzle. We ask questions, they give answers, but it flows very neatly one to the next. Our answers fit in through our discussion. To our students and their stressed out brains, what we do by sending them to the reading unguided is we essentially ask them to embark upon this puzzle without the clues. And they show up to class not even really knowing where the boxes are in relation to one another. And when we get to class, it doesn't get much better for our students. They worry, especially this generation of students, they worry about whether they're going to be called on, whether they understand the material, whether understanding the material, what does that mean about them, and whether they're going to succeed in this profession. If they're called on, how are they going to be treated by the professor? And most importantly, how will they look in front of their peers? But we really, truly stoke the fire of student stress with what we do coming away from class. Coming away from class, we essentially heap on the expectations for our students. No longer are we worried about that lesson. We've moved on to the next and the next class discussion. But for our students, we expect for them to understand. We expect for them to take away from the reading what they should have taken away and bring in what we lectured about and the class discussion. We expect that they're supposed to glean from those same cases the skills of problem solving and analysis so they can solve a similar problem in the future. And we expect in every class, every semester, oftentimes all at once, for them to demonstrate those skills and to demonstrate their knowledge of the doctrine in a single assessment exam with little to no feedback. Our process is designed to saddle them with stress, and the bad stress, the sustained stress, the prolonged stress, the stress that perceived or otherwise is out of their control. So we need to do something about it. And if you think about it, why do we do this? Is it hazing? Is it tradition? Or is it my favorite because we're training them to think like a lawyer? I'll use this stage to offer this one thought on that. To send someone to reading, to send someone to our type of reading, the wide and varied voices of appellate judges, and try to figure it out on your own, then come to class and I'll teach you otherwise so you have to back out of that understanding, is not thinking like a lawyer. It's being treated like a law student. My two simple innovative disruptions, disruptive innovations. How are we going to look at our process and change it up to try to help students manage this stress? So first has to do with the flipped classroom. It actually has to do with where to put it and what to put in it. Think about, imagine if we took our flipped classroom and we arranged it before the reading. Imagine if I used the flipped classroom to introduce a topic, to host a conversation with my students about what they're going to learn. The background, the policy, the foundation, the backdrop that sets up their reading. Now, I've armed them going forward as they go into the reading. I've taught them what to look for and what's going to contribute to their understanding. I've actually helped them as a guide in their study rather than a weapon against them. And call it the overconfident law professor or the ego of a law professor, but I think as their teacher, as their educator, I can introduce a topic in my field better than the random assortment of the wide and varied voices of the appellate court. The second one has to do with these appellate cases. Now, these appellate cases are good for certain things. We're never going to migrate fully, I don't believe, from a case method to a problem-based method. But they do not lend themselves to the skills necessary. They don't lend themselves to students really embracing their role as an analysis and problem solving such that they will be confronted with a similar problem in the future and they are armed to solve it. So one of the things we can think about, one of the things we can do, and it's not with all cases, but with some cases, is that we can think, and my crude title for this is the headless case. We can take off, we can cause them to think like a lawyer by taking back, holding back, scrubbing the case, if you will, of its analysis and conclusion. You can turn a case into a problem by taking out the court's analysis and the court's conclusion. Can you imagine anything more intimidating, more stressful to a student that's in law school trying to learn about all this, that's hearing from the great jurist of the time about how they decided it, right? It doesn't force them to think as a lawyer themselves. Instead, it says, well, that must be the answer. Let me look at the conclusion only. But if we set up the course in the right way with introducing the topics first, and then we hold back for some of these cases, we hold back the analysis and the conclusion. Now, students know what to expect when they get to class. Students know that we collectively have work left to do because we're going to take that set of facts and apply different law. Maybe it's the federal law, maybe it's the state of California, maybe it's what they do in the military under this unique statute, right? We're going to supplant and put in and work through essentially a case, but turn it into many problems. And now, think about what's happened with our student. Now we're working on the crossword together. Now I've given them the clues ahead of time. Now I'm guiding them and I'm not the weapon against them. So what I want you to think about for your two simple, innovative disruptions, disruptive innovations, what I want you to think about is hosting your flipped classroom and putting it in the sequence, putting it in the process before the reading to help them through the reading and help them make their way to class where it's all positive and all in the same direction. And with these appellate cases, for some of them, turn the case method into the problem method by holding back the court's analysis and the court's conclusion. And think about it, if we want them to revisit this material, if we want them to go back once again, then what we do is then we release the full cases. They get to see good, bad, or ugly what the court came up with relative to the class's project. Thank you for your time. I want students to think like a lawyer, and I want them to begin to engage in the skills that's going to allow them to succeed as one.